In today's video, we are going to talk about the Supreme Court. There was a ruling where debt collectors, now check this out. This might shock you, but it may not shock you. Debt collectors who violate the Fair Debt Collection Practices Act, any of the violations in there, that there is a statute of limitations on when you're able to sue them or to try to get your case turned around, have it reviewed, whatever. There is a 1-year statute of limitations. Now, let me ask you this question. When do you believe that statute of limitations would start? In most people's eyes, in most people's thought patterns, in most people's universe, they would think that as soon as they discovered that there was a violation, then they would have a certain period of time that they could do something about it. Well, I'm about to tell you that it does not work that way when it comes to what this Supreme Court decision that they made. And it was actually argued in 2019. I came across this because I'm always trying to look at what's going on with the Supreme Court and different courts out there that are listening to cases that are being brought against debt collectors. And this one here is Risik versus Clim. Now, you know, when you look at these names, I hope I'm saying this right. You know, the English language is one of the hardest languages to learn because you got all of these different silent, silent letters with certain words and then not silent with other words. I remember there was a video that I was watching, I think it was on TikTok, where the guy was like trying to teach a person, the English language, and he was just asking them questions like, is that not, he said, what is that word? He said, note. And then he said, okay, what is this word? He put a K in front. And he was like, connote. And he was like, no, the K is silent. The K is silent. Or it was like noun or something. And he was like, canoun. And he was like, no, the K is silent. And then I remember with Shannon Sharp and Ocho Cinco, when they were talking about the meat, the steak, Wagyu, and Chad Johnson said Wagana, and it was like that. It's silent. It makes it difficult. For the English language. They say, how do you know what's the difference between an American and other people? That Americans speak one language. That's because Americans' language is like 5 different languages within a language with all of these silent letters and also the different meanings. So, okay, enough of that. Some of the times you might think that the laws are just against us, the little guy, the person who's just trying to make it day to day. All we want to do is, you want to wake up, have your day just go the way that you maybe, not even dreaming about it, just saying, just let this day go by good. I wake up in a good mood, go to work, people leave me alone, let me do my job. You got the kids off to school before that. They hopefully they don't act up in school. You get home, you have a good meal, the kids don't act up, and then you top it off by getting ready to, have a good night's sleep and start this whole cycle over again. And but some of the times you can see stuff in the news, or you come across some videos, and like what I'm going to talk about here, where it just seems like sometimes like the courts are just against the little guy. And what I mean by that is, when it comes to corporations, it seems like they get so much leeway. They can file bankruptcy, reorganize, not pay, and it doesn't come back to the individual, which is good. Business is business, personal is personal, but it just seems like it gets stacked up against the individual. When it all comes down to it, the individual always pays. Individual always pays. They made it harder for people to file bankruptcy. You got to go through a means test. it just sometimes it just seems tough. And this here, I think, adds on to that toughness. But the way we do it here on the Credit Repair Shop channel is that we always just say, okay, now that I know, I just know that I got to be ahead of the game. I just got to be ahead of the game. So pertaining to this situation here with Rakinski versus Clim, 2019. So basically, this individual was going to get a mortgage, and then they found out that they had a judgment on, in their name. So when they do the title search and you have a judgment and it's not paid, you can't get the mortgage. You're not going to be able to get the mortgage. And this individual was like, hey, I was denied a mortgage, but I didn't even know about this. I didn't even know. And so he ended up suing this debt collection attorney who had purchased the debt. It didn't really identify fully. What I'm thinking is that there was a debt collector purchased a debt, and then they hired this company. This was over a credit card debt. Hired this company to try to collect on the debt, this Clim law firm. And let's see here. So basically what he's stating is that I did not know that I had this debt collection out there. And then they got the judgment, and he didn't know that he had a judgment against him. They state in there that they sent it to the last known address, no response, and then they were able to get the default judgment. Let me tell you how that happens. See, if they send it to your last known address, the next thing they do is they publish it in a newspaper. And I know that there ain't too many newspapers out there anymore, but they publish it. They might also publish it online now. That might be the new way of doing things. I'll let you know when that happens. Right now, I know that they still want them to publish it in print, but we know that that's going to be changing pretty soon. But they published it, no response, default judgment. Years later, going to get a mortgage. Hey, you got this judgment. What about this? I didn't know about it. Like, you know how some of the times people be like, I didn't know about it, but they know about it. This person legitimately did not know about it. Just legitimately. So bottom line, this is what the whole court case was about, was that he felt that because the law firm did not do the proper debt verification according to the Fair Debt Collection Practices Act, that they are in violation. That's what the bottom line is, that they're in violation. Now, there's a 1-year statute of limitations though from the time here, I'm going to tell you there's a statute of limitations, but then I'm going to tell you how it applies to us as individuals. So there's a 1-year statute of limitations to if you find that a debt collector has violated the Fair Debt Collection Practices Act, anything in there that's provable, you have 1 year to bring a case against them. 1 year, when you find out. Now here, let me clarify. It was well past the time period. So what he took them to court for, and it went all the way to the Supreme Court, he said that it should be when I discover. Now, logically to me, logically to you potentially, is that when you discover, like, how do you know if you don't know something happened to you? How do you know that there was a company, a law firm, did, I'm missing my word, violated, law firm, let me start over, law firm violated the Fair Debt Collection Practices Act and got a judgment against you, and you didn't know until later. So when you found out, wouldn't you logically think that that's the time that you could actually start the 1 year period to be able to do something about it? Like, okay, I know about it. I have 1 year time to figure out what I'm going to do, if it's going to be something worth doing, or should I just go ahead and take care of it? It was my debt, even though they have the Fair Debt Collection Practices Act is there to make them go through the proper process to do what they're going to be doing if they're going to collect on it or take you to court. Like that is there for protection. So wouldn't you think that you would have, you got 1 year to, that there's a 1 year statute of limitations for you to be able to do something about it once you find out. But here's the capper. This is what the whole case was about, is that this was well past, I believe, 5 years. 5 years past. I don't have it in my notes here. About 5 years past the time frame for when the individual found out about it. I think it was 5 years, but that doesn't matter. This is what matters, is that according to Justice Thomas, who delivered the opinion of the court, so we already know which side this was leaning on, is that it says that the statute of limitations does not start when you find out about it. It starts from when the violation occurred. So let's think about this. You don't know that there's a violation. You don't even know that you even have a case against you. You don't even know because you were not aware that you even had to be in court. You didn't even know that they got a default judgment against you. You just did not know. And now 1 year passes, 2 year passes, 3 year passes. You go to try to get a mortgage. Title search is ran in your name. And now you know. And that's called discover. When you discover, you would think that now I have 1 year to either deal with this with a lawsuit or, corrective action, whatever. Well, according to this opinion written by Justice Thomas, it does not start when you discover that there was a violation. It does not. It starts from the day that they did the violation. So if you're not aware of it, it does not matter. Now, they did say, which I believe would be very tough to prove in court, but they have their reasoning behind this stuff, so we got to go with it. They said that, let me get to my notes here. Okay. Fraud-based discovery rule. So what they're saying, this is how they kind of, gave the debt collectors their victory, but then gave a door opening for consumers. Open the door for consumers, which is really telling you what way you would have to point to. But I think that the door that they open for us consumers is a very difficult door, because they said that it would, for this to be able to for something like this to be able to be reopened up, to be able to have something, be able to go into the debtor's favor from something that they didn't even know about happening. This is the crazy thing. Person didn't even know that this happened. Is that they would have to say that this would be a under the fraud-based discovery rule. So that means that you would have to prove, this is crazy, you would have to prove that the law firm did everything under fraud, like they sued you, it was fraud, they didn't want to get you the information so you would know, all of this stuff. Like fraud, just think about it. If the Fair Debt Collection Practices Act says that you have to send it to the individual, and if you can send it to the individual's last known address, if they move, last known address, if it's not forwarded, if they don't put a forward on there, it's not going to get to that individual. Fair Debt Collection Practices Act say that next thing, when you take someone to court, that then if you can't find them, you send stuff to their last known address. That's good enough. They publish it in the paper. But let me tell you, just even thinking, I'm glad that I try to just think about stuff. So I appreciate everyone watching the video. And this is the reason why my videos, why I take some time and I might seem like I'm rambling and I'm going through stuff, is because I'm thinking, and I'm thinking about what the other side might be thinking and what you need to be thinking, and in different options that are available. And something that came to my mind, there's something that came to my mind that they did not mention in here, or maybe I missed it, but this goes to where when people are not in the situation of individuals who owe debt to debt collectors, who go through this type of stuff, they don't know the processes. They just got, this law, that law, everything by the book, blah, 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 all of that stuff. But as an individual, let me tell you something that happens. Regardless if you know, and this is what I think they said to this gentleman without saying it. This is what they said to him without saying it. And I don't see that they brought it up. When you when you have a credit monitoring service, or if you are of the mindset of caring about your credit, there would have been a time that this individual would have found out about this situation here. There would have been a time. That's what comes to my mind. And they don't say it. They don't say it. Have you ever heard of things like there's words, read in between the lines? Read in between the lines. Sometimes they have people where people are like, you don't see it my way, you don't see it my way. Why are you skipping over this? And it just seems like they're just bum rushing with the law. Hey, this is this, and this is the way it's stated, and there's a 1-year statute of limitations. And you want to know what the in between the lines is? This is what the in between the lines is. And because people that have never been in this type of trouble, never had debt collectors coming after them, never missed a bill in their life, they don't, the reading in between the lines is they expect you to know. They expect you to know. Now, the reading in between the lines for me and people like you and us is that if we're going to be in charge of our credit, if we're going to treat our credit as if it's a business or as if it's a bank account, because in a way, our credit is a bank account, because if you can't utilize your credit to get the things that you want, like this gentleman was trying to get a house, the credit is like a bank account that you're going to cash in on to get approved, and then to be able to get a certain interest rate. You got to know what's on your credit reports. And reading in between the lines, like some of the times when I read these decisions, and I'm like, you could just tell that they've never been in the situation, and then but they have that mindset of like they trying to tell the person, like they may not know the ways that the person should have known about it, but they have this mindset, they have this way of speaking of like, you should have known that you had this judgment. You knew that these people were going to come after you for this money. That's how they write the decision. Is they have that type of mindset when they write it. And then us, what we think about is like, hey, we're on the side of, we got to know what we're here talking about credit, and we want to make sure that we know what's going on with our credit. And so we, in a subtle way say, you need to, if you had credit monitoring and you really care about your credit, you would have known that this company would have been after you. because this is the steps. And I believe that they did prove these steps. Is that number one, if a debt collector buys your debt, they're going to send you a dunning letter. They're going to send that to the last known address. If you do not respond to that letter within 30 days, any dispute, any part, all, whatever, they're going to have legal authority to place that information on your credit reports. Once they put that on your credit reports, you're gonna know that it's, something's going on with your credit. And then you would have another opportunity to dispute that information and have them do debt verification, debt validation, everything that you should ask them for to make sure that they can prove that they should have that debt, that they can make you pay that debt. If they can't do that, they would remove it off your credit reports. Next step, if you don't do anything about it, they could potentially take you to court like they did with this individual. And if you do not show up to court for whatever reason, didn't get, you were served at the last known address, whatever, they're going to get a default judgment against you. Once they get that default judgment against you, you have a certain period of time to reopen the default judgment. That is under a statute of limitations. If it goes past that time frame, you cannot have it reopened. And even if it's not your debt, you can't have it reopened if it goes past a certain period of time. And then now, if you find a violation and it's past 1 year from when they violated, not from when you found out about it, not from when you discovered the violation, when the violation occurred, you would not be able to do anything about it. And that's according to the Supreme Court. So I guess to close it all out is that we got to be ahead. We have to be forward thinking about our credit. We have to know what we want for our goals. We got to know what, just fully take full responsibility. Yes, there's things that can happen. But if we take action and be forward thinking, a lot of this stuff would not get to this, would not get to where, things happening in court or things, you just don't know what to do because you're thinking ahead. If you got a case coming, what can you do about that case? Not just stand there and let things happen like most people do. All right, if you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, What Makes Us Different. So you can see my 8-point validation process, my 2-phase settlement process. If you need your credit reports and scores, go to the website, yourthenumber3scores.com. It is worth just knowing what's on there. You might see something. What is this? Like this person, if they would have had credit monitoring, they would have known right away, hey, something is going on. This is wrong. I need to do something about it before it gets to the next step. Go to the website, yourthenumber3scores.com. The link is below this video. If you have debt collectors coming after you early, use my 3-pack of letters. Statute of limitations letter, which also had said that this debt was past legal statute of limitations to collect, I believe. Or maybe it wasn't. Statute of limitations letter for debt that's past the legal statute of limitations to collect. Debt validation letter and cease and desist collection activities letter. Use the one that's appropriate for your situation. Thank you for your time. This is Stephen A. Williams, president and founder of thecreditrepairshop.com.